relative to the determination of parental rights and responsibilities and establishing a presumption in favor of shared residential responsibility. This is a very difficult discussion for the parents, let alone children. So I'm going to ask that the child that's in the room not be in the room during testimony.
The child actually wants to speak because he wants to give you the child's point of view considering what's been going on. I'm Janet Del Fuego. I'm sure you've seen me all over Facebook. This is my son, Samuel Gold. He's 14 years old. He's a motocross racer. He's an AP student, and he's more than adult-like to tell this panel what he's been going through for the last 3 years.
Did he fill out a pink card?
Yes, ma'am, he did. He asked me to come here today.
His name is Sam?
Sam Gold, ma'am.
Okay. Then what I will do is I will ask him to testify first and then ask him to leave the room.
Okay, I agree to that.
I don't want him to hear any information that could be detrimental to his well-being.
Okay,
Is my concern and the concern of some of my committee members.
okay.
I understand that children are affected by this conversation, period, end, but there is some part of the conversation that they don't need to hear.
Yes, ma'am, I totally
Bad
agree with
enough they
that.
have to live it.
That's right, and that's why he wanted to come today, because he wanted to tell you exactly what he's living.
Okay, so with all due respect to Representative Edelblut, as
My testimony will be pristine. Nothing
I'm
that I have to
sure.
say will offend the ears of a 14-year-old.
I'm sure.
Especially a motocross racer.
However,
But Representative Krogerberg is concerned about her ears.
yes. So I would ask you to indulge me and allow me to call you second as opposed to first. Well, you know what? I'm going to go with my original thought, and Representative Edelblut, when I call this to order, I will call you first because I'm sure that it will be pristine, and not to say that anybody else's won't be. But you'll be able to introduce the bill. So, it is now 2 o'clock. I'm going to call the hearings on House Bill 1118 to order. And with that, I will call Representative Frank Edelblut, who needs 6 minutes, he says, but he usually doesn't.
He usually goes.
Well, I think you're a fast talker.
Okay, so this is a companion bill to House Bill 1117, which we voted to pass this morning, which I'm grateful for. And I call it a companion bill because in this committee we have heard 2 systemic problems again and again come before this committee. And so this is yet another attempt to try to shift that systemic problem. This, again, is not all of the solution, but it is moving us in a positive and in a constructive direction with the objective of trying to reduce the degree of conflict in what is inherently a very conflict-filled situation through the divorce process. Because what we know again and again is that children are the ones who suffer from that conflict process. Now it's interesting because we use here in New Hampshire a standard which we call the best interest of the child. I mean, how can you argue with the best interest of the child? What a great line. We all have the best interest of the child. Unfortunately, the way that our statute is crafted, it does not put the best interest of the child forth in all cases. And in fact, sometimes, and in fact maybe many times, it puts the child at the center of the conflict. And as such, has the risk of causing really undue harm to the children. And so that is, again, what this is trying to correct. Like HB1117, I spent time with experts in the field, and I apologize that other committee members were not able to join me in that process, but I went to Judge Kelly, I went to Judge Foley, I went to and I worked with Jay Markell with the goal of trying to say, you guys live in this system every day. What can we do to try and reduce some of the conflict and animosity that exists or that results And in many cases, you have to understand that these are the very judges who get accused of creating these problems. So I'm trying to say, how can we all work together to solve the problem? And let's not create an us and a them type of a situation, but we really all do want the best interests of the child. There's not a person in this room who doesn't want that. And so the question is, how do we get there? What I would point to is that the current system, again, with the best interest of the child, is trying to achieve the impossible. It's trying to set up a situation where you've got a judge in a Solomon-esque type of a situation, in a hearing, trying to make a determination of who's the best parent, who's the most fit parent, what's going to be the best, parent for this child, if they're 6 years old until they're 18 years old for the next, 12 years. And yet that dynamic is going to change many times over the next 12 years as that child grows up. And so we need to create a situation that is going to serve the interests of the child over the long term. Now I've handed out two things to you. One is a series of case studies. This is peer-reviewed academic research. It is unanimous among all of the experts all around the world that two parents involved in the lives of the children, when you don't have an extenuating circumstance of abuse or something like that, but two parents is the best situation for the kids. The kids, if you're concerned about opioids in this state, you'll pass this law. If you're concerned about crime in this state, you'll pass this law. If you're concerned about delinquency or difficulties in school, you'll pass this law. Because the way that we are currently set up, we're contributing to these problems. And again, this is, you don't have to take my word for it, because I don't claim to be an expert in this, but what I can tell you is that, the experts do say this. Now, many of you also received yesterday an email, and on this committee we received many emails, but we received an email yesterday from, Dr. Vandenberg, and he describes his situation, the process whereby he was alienated from his children and hasn't seen his children in 7 years. This is not in the best interest of that child. If you care about that child, we need to do something. Now let's turn to the bill real quickly, because I know my buzzer's going to go off, and I do appreciate the buzzer. And if you go to the bill, you will see basically the structure is such that the best situation is the two parents come to an agreement. If the parents reach an agreement about how they're going to parent their kids and who's going to have custody and where they're going to go, boom, that's what stands. But sometimes that's not going to be the case, and that's what we're trying to work on here. And so that is item number 2. So item number 1 is an agreement made by the parties. That's how we're going to proceed. But if there's not, what we've done is we've tried to create a structure, a framework, and this is what I work particularly with Judge Foley on, in terms of how to structure something so that he can help perform his Solomon-esque type of a task. And so the first thing you'll notice is that we have a court, basically we've got a court finding by a preponderance of evidence. So we've reduced, we don't have a clear and convincing evidence, but we've got preponderance of evidence. 1 minute left, I'll have to talk really fast. Preponderance of evidence, so that we're not putting children at risk. We're not creating some high evidentiary burden on the court system to try and prove that there's a risk to the kids. We're basically looking at a preponderance of evidence. But we deal with abuse. And I have spoken to the abuse, to the domestic abuse, lobby and talked with them. And so I think that this is, we've taken care of that. We talk about neglect. We talk about interference with custodies. We've got incarceration. If you're in jail, it's going to be hard to parent very well, isn't it? And then you'll see, I even carry forward the aspects of the best interest of the child definition in terms of the ability and disposition of each parent to make joint decisions concerning the welfare of the child, foster a positive relationship. These are some subjective things, and so it was not easy to keep those in, but dealing with, talking to the attorneys, talking to the judges, this is where we needed to go. So I just want to make a couple of other points on the bill, because then you get to Section B, and we talk about the court shall issue an order that provides for frequent and continuing contact between each parent and the minor child. This is an essential element of effective parenting. It's something that we all want to see. I don't want to quote Judge Foley on this. Okay, I'll take this right.
The audience will hold their comments until it's their turn to speak.
Okay, so he understands the importance of that, and so he's supporting this kind of concept. We talk about there shall be a rebuttable presumption. So basically what we're doing is we're starting at 50-50. We're starting to say like both parents need to be involved in the lives of the children. Now what you're going to hear is testimony against this. You're going to say, well, we wanted to start out neutral. Well, that is neutral. That's saying the guy's got two parents and both parents need to be involved. That is a neutral position to start at. And that is where we are starting this. And so with that said, I believe that this is going to make a significant difference on behalf of New Hampshire families, and I hope that you'll support the bill, and I'm happy to take questions, which I'm sure there'll be many.
Representative Edelblut, I'm going to ask you to have a seat and let the young man speak, and ask the committee to ask their questions after the young man speaks, just in case those questions get into muddy waters. Yes, well, he can sit where he's sitting as long as he doesn't discuss or ask any questions of Representative Edelblut. Remember, you cannot ask any person testifying any questions at all.
Got it.
You can have my home phone number for afterwards.
Okay,
Would you
so
like me to
we're
turn
going
off
to
the
bring
camera?
Representative
Absolutely
Edelblut
not.
back at the
He's been
request
on
of the
TV more
committee.
than once.
So now I would like to call to Sam Goad. Is that your name?
Mm-hmm.
Have a seat. You have asked for 5 minutes to speak. Relax. I don't know of anybody here who bites. Okay? So, go ahead.
I'm Sam Goad, and my brother moved out of our house 3 years ago, and then my mom lost parental rights to my brother, and my dad I haven't seen or talked to in 3 years, and then just recently, well, like a year ago, he took money out of my bank account that wasn't his, and he won't put it back, and that I've asked multiple times to put it back, and he tried to convince me to leave my mom's house and live with him, because he was saying my mom was in unsafe there. And then my brother, we were getting along, and now we're not. We talk occasionally, but we fight when we do.
And how old are you, Sam?
I'm 14.
And how old is your brother?
Turning 16 this month.
Does anybody on the committee have any gentle questions for Sam? Representative Chase.
Mine isn't so much a general question as to say that there are a lot of us sitting here that know how much courage it took for you to get up and say this. You did a good job.
Representative O'Leary.
Thank you, Madam Chair, and Sam, thank you for your testimony. It's not often that we have such a young man come brave enough to tell us how things are going. This committee tries to put laws together so when families break up, it's the best way it can be. And so we're interested in knowing, since you're part of this, what could we have done? What could we have done better? You know, if you got a do-over, how could we have done better so it would have been better for you and your brother?
Probably changing the courts, because the courts issued full custody for my dad to have my brother. My dad won't let me see my brother that much.
Follow-up?
Yes, Representative.
Thank you, Sam. So if you were the judge, you have only you two brothers? There's no other brothers or sisters?
Just us two.
Just you two? So what would you have done as the judge? As opposed to give your dad custody of your brother, and then I assume your mom custody of you, what should the judge have done?
I think the judge should have allowed custody, partial custody for both of us, for me and my brother, and we both, I see my dad, and my brother sees my mom too. But now that it's been farther in, I don't really want to see my dad because of what he's done.
Understood. Thank you, Sam.
Thank you, Representative. Any further questions for Sam? Seeing none, thank you, Sam, and again, I'd like to applaud you for your maturity and your courage. And I'm going to ask you to have a seat outside and call other witnesses. And if we need you for any further questions, we'll ask you to come back.
Okay.
Thank you very, very
You want
much.
to stay with me? You want to go and see him?
Yeah.
Okay. She wants to go with you.
Ask Representative Edelblut to come back and ask the committee if they have any questions for the representative.
Hey, oh, that was good, no,
Representative Rice, you have a question.
Thank you, Madam Chair.
You are very welcome.
Thank you, Representative Edelblut, for taking my question. So my question is, because I don't have both bills side by side, what do you think that in making these changes, the outcome will more likely be less conflict and more shared parenting? Will this encourage parents also to come to their own agreement?
Yeah, so it does a couple of things. So, I mean, the first goal is relative to the children. We talk about the best interests of the children. And all of the research points to the fact that the children thrive when both parents are fully engaged and actively engaged. And that's really what we're after here. I mean, we just heard testimony of, an order where you've got a kid, one's with one parent and one's with another parent. That's not good for either of the kids. I mean, if we care about these kids, we want to create a system that would say, like, yeah, it's joint custody. Now, to your point, had the statute read and said this is going to be 50-50, I believe that the parents would have been encouraged to try and find a way to make that work, because that's where they're going to end up anyways. They either come up with an agreement that it works for them, or we start at this presupposition, this rebuttable presumption, that they're going to share 50-50. Did I miss a piece of that? Yeah,
Please.
okay.
So, in that being said, what's to say the judges are gonna follow it?
You know what, well, it is the law, so we'll start with the law, right? And the one, some of the teeth is that we have created the rebuttable presumption. So that in the event that we find a situation like we just heard about, then at least what we've done is we've created grounds for someone to be able to say, like, you know what, if a judge were to award children, to both different spouses, then at least someone can come in and say, like, is there a basis for that conclusion? Why are we doing this? Is this really in the best interest? So we can actually engage that dialogue and try to come to a conclusion, whereas too often we get testimony of there's this opaque process that doesn't actually help us to reach the best interest of the child.
Thank you. Representative Ingridson.
I just answered my question, thank you.
Okay. Representative Hennessy, and then Representative,
Sorry, are you finish your sentence?
if they're,
Barry.
He's trying to remember Skip's name, right? Okay.
can you tell me?
Thank you, Madam Chair. I understand that I may sound like a broken record, but I also understand that part of the theater of this process is to have, to bring in compelling cases. And I just want to ask if you have any people in mind who are going to give both sides of this. If there's, we only know, I'm very sorry that that boy had the experience he had, but I don't know anything else. I don't know anything about why the father got certain. I don't know if you have any of that information about what, that you can share, or it's just I'm trying to get to the bottom of the whole picture, that we need to see the whole picture.
Right, so what I can tell you is that I've not actually had conversation with the other witnesses. I didn't know who was coming or not coming to this. The only conversation that I have had is with Judge Kelly and Judge Foley and with Jay Markell, who wishes he could be here, but he's on a trip in Puerto Rico right now, enjoying himself as he calls it a well-deserved vacation. So really, those are the people that I have worked with combined really with the testimony that you and I have both shared in this committee, so.
Thank you. Representative Varian.
Thank you, Madam Chair. Thank you, Representative Edelblut. I think we do kind of share the broad intent of your proposed legislation. I'm wondering if you can comment on how and why it is different from what currently exists in statute.
Right, so what we basically did is, if you go to 461A6, that is the determination of the rights and responsibilities of parents in the best interest of the child, it's actually quite a, I'll refer, and I hope this is a term that makes sense, it's a software term, but a kludgy law. Is that kludgy? You know what I mean? It's like, it's over verbose, and it repeats itself, and it doesn't provide clarity just because it has more words. In effect, what it does is it actually kind of makes it more difficult to understand and more difficult to necessarily follow. So there are components of that which we have brought forward, and there are components of that we said, well, this is really redundant. It's not necessarily going to help us. I mean, all the way down to, I mean, look at G. You know, any other additional factors the court deems relevant. So which again, this is we're shifting, but we are not in the process of, you know, eliminating judicial discretion. You know, I'm not trying to ruin and bring the court system to its knees by some legislative mandate here. We're trying to help them get their job done is what we're trying to do. And so I think we've done, you know, quite a bit of that. So you'd have to, and we can go through each individual, you know, best interest of child standard in 461, and we said, is this in, is it out, and then you'll see E, you know, which is one that we thought was important, dealing with the ability and disposition of each parent to make joint decisions concerning the welfare of the child. This is really, when you talk to the judge, this is a very difficult thing to make. You get these people, they show up in court, they're on their best behavior on this, they put on like a little angelic faces, and they go in there and they act like they're saints. But in fact, we know from many times the testimony of this committee has revealed to us that maybe when they are outside of court, they're not as saintly as they may appear to be. One of the items that we went back and forth actually on a couple of different times was F, you know, the relationship of the child with any other person who may significantly affect the child. And this was a situation where sometimes what you end up with is and again, and I illustrate this because we're saying we try to think through scenarios. There's a lot of times where there's there's parental conflict, and kids end up with a grandparent, you know, and so we want to make sure that we don't like rule out the fact that the grandparents may be this, you know, to have a relationship that significantly affects that child. So we try to include these kinds of scenarios that the court is faced with on a regular basis. Is what we've done. So I think what we have is a more easily followable, you know, statute. It provides more protections for the participants in the process, vis-a-vis starting at neutral, starting at 50-50, you know, which is the neutral, you know, and providing the ability to have the rebuttable presumption. So,
Thank you.
yeah.
Senator Williams?
Thank you, Madam Chair. Thank you, Representative, for your testimony and your bill. We've heard similar bills before this committee. We've talked about this topic of judicial discretion ad nauseum for 30 years. What we just witnessed in here was a young man who can't see his brother. He's 14, his brother's 2 years old, can't see him. I would highly suspect the court order isn't preventing the parents from swapping the kids. But
And
what
your
the court-
question, Representative?
So my question is, what I suspect this court order did is created enough conflict between these parents and giving one custody and the other custody of the other child, that they're not cooperative. So my question, sorry that it took me a while to get here, my question is, do we suffer, this committee in this house, suffer from a lack of understanding of the best interest of the child versus the best interest of the parent? Are they mutually exclusive, or are they actually the same thing? Do we suffer?
You know, honestly, I think that's beyond the scope of my ability to answer that question. Overly complex. What I will answer with is I want to read from, you know, a peer review. We did 40 studies, you know, that were peer reviewed, and it says, overall, the children in shared parenting families had better outcomes on measures of emotional, behavioral, psychological well-being, as well as better physical health, better relationships with their fathers and their mothers, benefits that remain even when there were high levels of conflict between the parents. So my point is, the parents might still be at war, to your point, but if there's involvement by both parents, it's better for the kids. So if you care about the kids, then that's what I'm trying to push as well here, so.
Representative King.
Did I understand your response to Representative Varian's question to be that you rewrote it to make it simpler, but that it isn't really any different?
I think that would be a mischaracterization. I think it actually is different because it's a more efficient statute. It will be easier to apply because there's not the, as I refer to, kludgy requirements in it, as well as it starts and it has as its underlying presupposition both parents active in the engagement. That's what's best for the kids, as opposed to kind of or ambiguous standards of what's best for the kids.
Thank you for that clarification.
Representative Long.
Thank you, Madam Chair. So I'm on board with this. I understand what you're trying to do. I wholeheartedly agree. My question is on, like, when I started getting to E, F, G, again, we're given judicial discretion, so there's gonna be constituents that are gonna have an issue with the judicial, with the discretion that the judge determines. So that's problematic. That's the same as I see in the current bill. And I certainly understand this study and its claims. I could get that, even with parents that are in conflict. I know a lot of people that are parents are still going at it. And, their kids are handling it. They're doing well. They're seeing both parents. They're happy with it. That's, nature of the beast. So, my question is, at what point, so I'm looking to determine when does harm exist. I mean, when does harm? Obviously when Sam spoke, I can see the harm. He has a brother that, he's not able to, get a relationship, a positive relationship, to the point where he's getting angry at his dad and in some respects take that out on his brother because that's that side, I don't know that, but I would think that may also happen. So, my question on all this is when is the harm? When in this study, does this study reference any harm? At what point it becomes harmful?
Absolutely.
It does?
Yeah.
Okay.
Because again, this is, the first sheet is just
So where could I
a
find
study.
that?
A lot of different places in there, but I will describe the harm. It's right on the first page. I'm reading to you. It talks about emotional problems, behavioral problems, psychological well-being, physical health, relations with the fathers and mothers. And these, again, it states, are benefits that, transcend and continue on. And we would be, I hope that we can achieve all these benefits, but imagine if we don't, because the antithesis of that is that they have emotional difficulties, or that they have behavioral difficulties and they opt out in school, or in the prison system, or in the juvenile delinquency system. Again, I come back to, think about this opioid crisis that we have here. So the young man, he's not in here, but I mean, imagine if the situation that we've created here in this state is one that causes emotional, behavioral, and psychological problems for this kid, that he has a higher preponderance to addictive behavior later on in life. I mean, are we contributing to this problem in ourselves by not solving this problem? So that is what I would offer up to you.
Yeah, I haven't seen it in here, how it's being caused, but I'll go through this and just get this today. And, with respect to addictions, it's any trauma. So divorce is a trauma. So the fact that they're getting a divorce could lead to.
So I'll give you another one. I mean, here's, if you want some more damages, if you want to go to another study, this is the Bergstrom study. And it talks about, the growing body of research on the links between the children's mental health and the living arrangements after parental separation has shown lower risk for children in joint physical custody of children in single care arrangements. These include lower risks of fear, aggression, depression. I mean, is depression something that you want to throw that into the category? Because these kids who get depressed have to be treated medically, they have to be treated clinically. So that is a harm, I believe, that we're due to these kids. Behavioral problems, risk behaviors. So again, risk behaviors does include lots of different things in the way they act out. So, and I haven't given you guys, you've got references to the whole site, the whole studies, and you're welcome to go read the entire studies. I try to make it easy for you and just give you the, certain pages that are kind of, help summarize the results. So.
Thank you. Representative Froberg.
Thank you. I don't see anywhere in number 2, parental substance abuse or alcoholism as a factor in custodial arrangements. Shouldn't that be
Yep.
there?
I'm trying to remember if it's in the abuse statute is what I'm sitting here trying to remember. In other words, so if you have a drug abuser in the home, is that not in the abuse statute? No, okay. So then that may be something that we want to add to this.
All right. And another one is follow-up, please.
Sure.
2A says abuse as defined in the RSAs with consideration to the impact of abuse or domestic violence. And my suggestion there is that domestic violence should be a separate category for a fine, not lumped in with abuse.
Yeah, so the difficulty was that we collapsed those statutes in our law so that the abuse and domestic violence are kind of, co-located legislatively, and that's why those are in that same sentence. So I deliberately added the domestic violence because I believe that's the 169C3
I
statutes.
think abuse would be abuse or neglect of the child.
Yeah, well, so
And
neglect is a
domestic
separate
violence.
category, right?
Domestic violence would be directed toward the adult.
So the difficult, exactly, so that's what this is. So with consideration to impact of abuse or domestic violence on the child could be, so that if you have an abusing spouse, right? Well, then you take that into consideration because they may not be abusing the child, they might be abusing the spouse. And so what this language, what I'm told, is able to do is that even if the child itself is not being abused through domestic violence process, if there is abuse between the spouses, that has an effect on the children and needs to be taken into consideration by the judiciary. So that's what this is trying. So I think we're saying the same thing. I think my words get there, but I'm happy to look at that.
It's more confusing.
Okay. But I think we're saying, in other words, I agree with you that spousal abuse has an effect on the children as well. And so we're trying to, I was trying to bring that in to this process.
Make it clear.
Any further questions for Representative Berrien and then Representative Thompson?
Thank you, Madam Chair. I just want to be clear. It seems that the thrust of this particular proposal is that there is equal and joint parental rights and responsibilities, shared residential rights and responsibilities are in the best interest of Is that the core of this? There are other things that kind of work around it, but is